Monday, the Kyle Rittenhouse trial could be in the hands of the jury. The final witnesses took the stand late Thursday.
Our Andrea Albers has been closely following the trial since it started, and Andrea joins us live now this morning. And Andrea, the jury is off today while the attorneys and judge get some important work done.
That's right. Good morning, Susan. Yes, the jury is not even going to be at the courthouse today, so we're in a bit of a holding pattern until Monday. The judge and the attorneys will meet sometime today to hammer out final details, but everything else is essentially on pause until next week when closing arguments are set to begin. On Monday, each side will get 2.5 hours for closing arguments. The judge and the attorneys have agreed to that. The judge is trying to limit the time somewhat because he knows there will be at least an hour of jury instructions to get through. During that time, the state is expected to ask for lesser included charges. It means jurors would have the option of finding Rittenhouse guilty of a lesser charge with a lower burden of proof and shorter sentence. It could help jurors avoid a hung jury in this case. And it is worth mentioning, no ruling yet on that mistrial request from the defense, but it does not seem like the judge is seriously entertaining that option. Reporting in the newsroom, Andrea Albers, TMJ4 News.
Thanks, Andrea. And let's continue our live coverage as the judge and attorneys gear up to meet today in court, joined once again by local attorney and legal analyst Patrick Cafferty. Patrick, good morning. Let us start with this business of lesser included charges. You are a defense attorney by trade. If it's your client, are you thinking, great, maybe my guy won't spend the rest of his life in prison, it gives the jury this out? Or are you thinking, look, prosecutors overcharged, they can't make it stick, and now they want to tell jurors, well, go ahead and convict of something?
Good morning, Vince. So you sum it up pretty well. One of the most boring things that happens during a jury trial is the jury instruction conference where the judge and the lawyers will get together and decide on how the jury is going to be instructed. So you all have been correct that there's not a whole lot to see today that's going to make for good television or excitement. With that said, some of the most important decisions of the case are going to be made today, and that includes the concept of lesser included. I fully expect that the defense is going to go for broke here. And by that, I mean they are not going to ask for lesser includeds. They are going to try to frame this as the jury should decide guilty or not guilty, and that's it, nothing in between. I fully expect that the state is going to ask the judge to instruct on lesser includeds on at least some of the counts. So I'll give you an example. One of the charges is first-degree intentional homicide. There's another charge that's called second-degree intentional homicide, and I do expect that the state will likely ask for that as an instruction. The penalty is lower for a second-degree intentional homicide, but it's still significant. First-degree intentional homicide contemplates mandatory life in prison. Second-degree intentional homicide, while armed with a dangerous weapon, contemplates a maximum sentence of 65 years. So from the state's perspective, there's not a whole lot of difference between those two penalty schemes, and they would likely be happy with a second-degree intentional homicide finding if the jury ultimately came back that way. So that's what I expect is going to happen today.
So with the lesser included, is that an indication that the prosecution feels like it did not do a very good job in this case, or is this something that we will find routinely in cases of this kind?
It's relatively routine that in homicide cases, juries are instructed on lesser includeds, whether it's because the defense asked for the instruction or the state asked for the instruction. In a case like this where you have so many counts and you have a jury that may be divided in terms of their political orientation, for lack of a better way of saying it, the state is going to be interested in giving the jury an out for a compromise. So if you go into that jury room and you have people who are really strong on one side versus people who are really strong on the other, they may deliberate for hours and hours or days and finally get to a point where they say, hey, we don't want to have a hung jury here. What if we rally around a compromise verdict here, and instead of finding him guilty of first degree, we go with second degree? Now, there are other ways they can do that on the other counts, but I'm just using that count as an example.
Patrick Cafferty, defense attorney, and our legal analyst. Patrick, have a good weekend, and we'll talk to you again on Monday.
Thank you. See you Monday.
Our Stephanie Haynes is in the courtroom every day and will bring us the latest on TMJ4 News at 5 o'clock this evening.